to see you are all here on this early hour of the morning. Can everyone hear me all right? Yes, good. Thank you for being here. My name is Jan van Banning. I'm a PhD candidate at the Vrije Universiteit Amsterdam. And I will be moderating this session. And today we are going to delve deeper into the role various legal frameworks and principles, such as the right to a fair trial, data protection law, and the AI Act can play in regulating data-driven policing. As you probably all know, the analysis of large datasets plays an increasingly important role in contemporary criminal investigations, and this will likely become even more so in the future. The possibility of combining datasets from various sources and analyzing them using both more as well as less sophisticated tools, including AI systems, presents existing legal frameworks with significant challenges. Parties to the criminal process may not know how to adequately assess the reliability or lawfulness of these analyses, especially if transparency regarding the use of AI tools and their functioning is lacking, and innocent individuals whose data is caught in the process may not be able to effectively contest this the processing of their data. In order to discuss these various issues, we have a wonderful panel gathered here today, consisting of experts in criminal law, data protection law, and algorithmic decision-making. The plan for the session is as follows. I will first let every panelist speak for about 10 minutes, and I will give a V sign when you have 2 minutes left. And I will then briefly allow the panelists to put forth questions for one another for about 10 minutes, and after that we will open the floor for questions. So, without further ado, I will give the floor to the first speaker, Professor Kathleen Ligeti, who is a full professor of European and International Criminal Law at the University of Luxembourg, and who will speak on AI evidence and fair trial rights.
Yes, thank you very much, Johan. Maybe I would still use one of my slides if they can put it up, and while it's coming, yes.
Yeah, the green one is the
pointer.
Yeah, green is...
Yes, green, this way. Yeah. Yes, it's so sophisticated. Yes. So, what I'm going to share with you this morning, and a warm welcome to all the participants, and thank you very much to Masha and Johan for the invitation to this panel. So thank you for being with us early in the morning. This is a challenge. So what I would like to give you is a bit of a teaser of research that we have done at the University of Luxembourg on AI evidence in criminal proceedings. You see the project website, the publication, it's open access, as well as a forthcoming publication on expert evidence rules and how these rules, in my view, should change in light of using AI. So this has been a large comparative research project, and I will just start by sharing you actually our findings, what we have seen, and we looked also across the Atlantic to the US, which is far more advanced in using AI, also in the evidentiary setting. But we wanted to look specifically for Europe, because there is far more use of AI in criminal proceedings that we might be aware of. And we wanted a little bit to unpack how AI impacts criminal proceedings, the participants, their roles, and especially the fair trial principles. So what we mostly see is that, and this is one of our findings, that AI is used in many ways in criminal proceedings, and I think that other participants in the panel will show you more. But what is striking is that if AI is used by law enforcement authorities, mostly it is taken as a lead, and we call it even as the AI lead paradox. So it's not the output of the AI analysis which is introduced into the criminal proceedings or the case file, but this output, this AI output, is used as a forensic lead to conduct further investigation, and eventually what ends up in the case file is the outcome of the human analysis or the human investigation. And here comes the paradox that this investigation was based on AI-driven leads. However, these leads and their impact on the criminal procedure in most European countries remains hidden. This is why we talk about the AI paradox. So just to give you an example, face recognition technology, widely used by law enforcement. It's not the face recognition hit which is introduced into the file, but it is the eyewitness who testifies in court. So the court, when looks into the credibility of the eyewitness evidence and the reliability of the eyewitness, it deals with the eyewitness, not with the fact that this eyewitness actually was confronted with a face recognition hit. What I would like to very briefly show you is a typology of different AI evidence that we see across Europe, and I think it's quite interesting for the remaining part of the panel. Most of the tools that law enforcement authorities today use in Europe, we call them in our research AI filtering tools. Most well-known is Hansken, and Masha has written, and others, a lot about it, to actually sift through large amounts of data to find images, chat materials, etc. There are many other tools which are listed on the slide. What is relevant for this category, that actually these AI filtering tools, and when I talk about AI, sorry, I should have made this disclaimer at the very beginning, I only refer to machine learning technology, so not about rule-based AI. So these AI machine learning filtering tools actually help law enforcement authorities to focus the investigation to be more efficient, but what they find, the chat or the child pornography image or anything else, is a piece of real evidence or hard evidence that a human investigator could have found, potentially. So when the evidence is introduced in court, an expert witness can easily talk about the reliability or credibility or authenticity of the chat or the image, etc., because a human could have found it. This is quite different from the second category of AI evidence. We call it AI-generated evidence, like facial recognition, automatic number plate recognition, forensic probabilistic genotyping, and some other tools that you can see on the slide, where actually the AI machine learning technology is involved in the evaluation of the data and producing the evidence. If this evidence is introduced in court, like a DNA analysis driven by forensic probabilistic genotyping, where there is machine learning in the algorithm, then participants in the criminal proceeding have a much more problematic standing in scrutinizing the reliability and credibility of that output. What is interesting, and I think I don't have much time, so I will conclude with this, that even though we have AI-generated evidence, still in Europe, most law enforcement authorities use even this AI-generated evidence as a forensic lead. So often face recognition technology or automatic number plate recognition or even virtual investigations are used more as a lead than actually as evidence. But, and this is why I have the two orange brackets at the end, you see that there is a much larger bracket for the AI leads because they are dominating today. But there is already, for instance, in case of DNA and probabilistic genotyping, already real evidence introduced into the criminal trial. And my assumption is that this picture is very fast shifting, and we will see more and more AI-driven evidence in criminal proceedings. Of course, the impact already of AI leads, and this is my last thought, is not neutral for the criminal procedure, because the machine learning tool brings a certain selectivity with it. The tool is trained in a certain way, so it looks for data that, it looks for the known, not for the unknown, and this can bring bias for certain groups. We also saw in the research that participants, especially the judge, trust these tools, so there is a certain automation bias, believing that these automated filtering tools find everything. But the reality is that we still need much more interdisciplinary research, how to calibrate the human-robot interface in designing such filtering tools to avoid over or under filtering, resulting in too much positive, false positives or false negatives. Certainly, the balance is tilted towards law enforcement. We interviewed some defense lawyers how they see the use of these filtering tools, and they said that even if now in the Netherlands and in Germany, we see a tendency that the defendant and the defense counsel is granted access to these tools. There is not much use to them because these tools are designed with an investigative hypothesis. So, for instance, when the defense counsel wanted to search in Hanscan in Russian, it couldn't because it's not done in a way that that would be possible. So our outcome is that we need to upgrade defense rights in order to meet these challenges of AI evidence and to really allow the defendant to scrutinize these AI outputs in criminal investigation. And the borderline between AI leads and AI evidence is also a very fluid one. And we should be mindful that AI leads have a very serious impact on criminal procedure. I stop here.
Thank you very much. Well, thank you very much for this very interesting presentation. I will then give the floor to Dr. Moshe Plessischer. I'm hoping I'm pronouncing your name, almost, who is a research associate at the Institute of Criminology and assistant professor in criminology at criminal law at the Faculty of Law of the University of Ljubljana. And she will speak on decision-making using AI during the criminal process.
Thank you. Thank you, Johan. Thank you, Masha, for putting together this panel. As Johan said, I mostly work on criminal decision-making, human typically, but increasingly also AI decision-making in this field. And I'm going to build on Kathalijn's thesis as well as her conclusions, in the sense that I want to look at the filtering or AI leads and how, even though it's not evidence per se, it still has a big impact on how the criminal process goes on, mainly in connection with the term that we often hear when using AI in legal proceedings, which would be human oversight, right? And the question that we will be asking in the next 10 minutes is, what do we actually mean when we say human oversight in criminal proceedings? Now, as we've seen already from Kathalijn's story, AI shapes decision-making at various moments of the criminal process. And I think one problem is compounded across the three stages. So if we look at the investigation, I think I'm not going to go deep into that because Kathalijn's already showed us how AI is being used in spaces where human decision-making really is not the best tool to do. If we have large amounts of data, if we have complex, different types of data to analyze, there are cognitive as well as time limits to what people can do with those amounts of data, and those limits are very, very different for AI tools. So it filters, it ranks, it prioritizes data that a human investigator could not possibly access even in the same timeline. What Kathalijn's also showed that various tools are used to do that, and those tools are what's typically reported in what comes into the criminal file, right? So the criminal file will not say, oh, AI was used to do this and this. It might say one of the several tools that Kathalijn's named was used on the presumption that we kind of know what those tools are and what those tools do, which is a very naive presumption. We don't actually know what they do, and specifically the prosecutor carrying on the case through the investigation stage and then later on, and the judge making a decision on that don't typically know, possibly even that AI was used at all. So when we talk about oversight, obviously we have different humans in the chain of the criminal process. One is the investigator, supposedly, executing human oversight over what AI produces. But we all know from forensic psychology problems of tunnel vision, problems when AI points out on specific ideas, it also does not point out on other ideas. And in a criminal investigation, kind of being open is one of the core premises of an independent investigation. So if we kind of accept that we want AI to channel the investigation, human oversight kind of becomes impossible, really, in many ways. There is obviously checking that what's being done is actually in the file, that what's being found is actually there, big pictures need to be there, and so on and so on. But the sole fact that AI kind of chooses what you see because you can't see everything is in itself a problem in the sense of human oversight. This carries on towards the prosecution and the pretrial stage and what the prosecutor actually knows about what's been done in the investigation phase and whether they also use AI tools or not. And this carries on towards the trial stage where judges are faced with, whatever is recorded in the file, which may or may not be transparent about what was used in previous stages of the process. And to compound the problem even more, we have judges who obviously are not immune to using AI as well. So we have systems like, Italy, who's bought ChatGPT for all the judges. We have systems like Brazil, who's building their own AI kind of infrastructure to assist judges in their decision-making. So it's 3 different levels of AI usage that are being compounded on itself and are especially not being very transparent. So the cumulative point is that this is one big mess. Sorry, the very technical language. So one very common objection that I would possibly make if I was on the other side of this table would be, but isn't filtering and kind of decisions taken at different stages something that always happens in a criminal process? So obviously the investigator always filters something and puts it forward towards the prosecution, and the prosecution filters and puts it forward towards the judge. So obviously, yes, this is something that typically happens, and it is a very normal kind of setup for a criminal proceeding. What I think is important is to understand that the safeguards that we have in criminal proceedings have been set up precisely to kind of address this problem. And we have, sorry, it wouldn't turn. We have, I think, 3 instances where AI kind of actually makes this problem bigger instead of smaller when it's used. One is visibility. So human filtering is kind of articulate. It has to be defensible. It has to have reasons throughout the stages. If a prosecutor is interested why something was included and something wasn't, they can ask the investigator, and the investigator will tell them why this was a decision being done. We don't have that same kind of transparency when we look at AI. The second problem is obviously scale, right? You can look through whatever a human has done, and you cannot look through whatever AI has done because it is just simply too big. And the third, which is kind of something I work on a bit more, is the systematic error, the danger of systematic errors that occurs when we insert AI into the equation. Human errors in criminal investigation are generally individual and random. We also know that there are systematic problems in criminal procedures in different systems, different ones. But generally, they are something that happens within a specific case. AI learns on those errors, right? And it makes what can be random errors a systematic kind of continuation of errors that have been done in the past. It replicates across cases what could have been done wrongly in the first instance. So what Katalin was suggesting, and what I'm very much agreeing to, is that we don't actually need something completely new or something completely different. We just need to, in terms of safeguarding the criminal procedure, we need to kind of reshuffle, rebuild the safeguards that we already have to understand how to address these challenges raised by AI. Yes. So back to the question of oversight, is meaningful oversight actually really possible in that setup? I don't really know. I feel very uneasy about this question. What I feel quite confident about is that AI use in criminal investigations will increase. We have a world that's much more complex than it used to be, and in order to kind of comprehend everything that's going on, we need to be able to analyze huge amounts of data, and this is where AI is actually useful and helpful. The question that we need to do is how do we curtail the harmful parts while keeping the benefits? And just as an aside, we have done this before. New technologies, new kind of forensic techniques are being introduced into criminal procedure, have been introduced, since forever. As science develops, our forensic tools develop as well. So we've introduced DNA and felt, oh wow, DNA is this perfectly objective and wonderful thing we can use. And then we saw actually, wow, we do make errors and it's not 100% accurate and so on. So we've introduced different levels of safeguards, authorization requirements, proportionality constraints, documentation rules, and so on. And I think this is the route we should probably be going with the use of AI as an investigating tool as well. We have other examples like, lie detectors that we felt might be a good idea, but then we saw, oh, wait, they're probably not a good idea, and so we left them aside. I don't really think realistically this is going to happen to AI, but I think at this point we should be transparent in saying those are the options that we have, because not having any kind of legal framework is not an option.
Thank you for this thought-provoking presentation. I will then give the floor to Dr. Teresa Quintel, who works at the European Parliament on AI regulation and data protection law, and who will speak on enforcement of the Law Enforcement Directive and data protection law in the context of the use of AI in law enforcement.
Thank you so much. Good morning, everyone. Thank you, everyone, for coming, and thank you to the organizers for inviting me, for organizing this panel. It's always a pleasure to discuss at CPDP, especially early in the morning on a rainy day. I have a first disclaimer, which is that everything that I will say today are my personal views and can in no way be associated to the European Parliament. And today I'm supposed to discuss the importance of the so-called Law Enforcement Directive and the principle of purpose limitation for governing the use of AI and for criminal investigations and intelligence analysis, and also the need to engage more with data protection and criminal procedure law. And maybe I can also build a little bit on what Moitza said on the safeguards and criminal proceedings, and actually rebuilding some of the safeguards, or by having data protection and criminal procedure law speaking a little bit more to each other, that we are rebuilding the safeguards we already have in place. I have another disclaimer, which is that I took a lot of my inspiration for today's intervention from a book that will hopefully be published soon, because as we all know, the world of data protection and data is moving very quickly, so the matters that we are speaking about are outdated very quickly. The book is written by Juraj Seifert, and it's about measuring the proportionality of different investigative measures. So should it ever be published, you should read it, but until now I will use its message so at least some of you can benefit from the wisdom in the book. I will start with my conclusions, and then I will explain, just in case there's not enough time at the end of the intervention to come to my conclusions. The first point that I want to make is that in the era of data-driven or AI-driven policing, more attention should be given to the respect of the purpose limitation principle in the Law Enforcement Directive. AI data-driven investigative measures should be developed for specified purposes. The best would be if the purpose specification would be spelled out in a granular manner already in the relevant legislative acts that are being applied by competent law enforcement authorities, and which allow for the processing of personal data for measures. So a legislative act should not only repeat the general objectives that we have in Article 1.1 of the Law Enforcement Directive, so which is the prevention, investigation, detection, prosecution of criminal offenses, but it should be specific when it comes to the purposes of the processing, and it should already lay down the data that will be needed for the processing for a measure. The second point that I want to make is related to the change of purpose under the Law Enforcement Directive and subsequent processing. So the repurposing of processed data should be allowed only under the conditions of the purpose limitation under Article 4, Paragraph 2 of the Law Enforcement Directive. And if we look at that provision, a change of purpose is only allowed when it is authorized by law and if it's necessary and proportionate for this new purpose. And because the Law Enforcement Directive maintains the balancing test at its core in the sense that for subsequent processing, it requires a legal basis and that the processing is necessary and proportionate, if purposes are specified in a granular manner, the need to change the purpose of the processing of the data will become necessary more often during a life cycle of data processed under the directive. So here we come to the purpose limitation principle as having a sieving, or as Moitza called it, a filtering function. So each time a change of purpose occurs, less data will be needed because it was sieved and the irrelevant or lower quality data or the data that are not necessary or those that are disproportionate will be discarded. So as an example, in the first step, the police will collect the data for their criminal investigation. They might collect much more data than they will need in the end. And then the first step of sieving will apply when the data is subsequently used by the prosecutor. The data will travel further, and the prosecutor will already deal with much less data because some of the data that were initially collected were identified as being no longer relevant for the proceedings. So as the subsequent processing continues, the sieving continues, and each time the purpose changes, the necessity and proportionality test will kick in. This means that at the end, only the good quality data will be left over after the sieving, meaning that only the data that are needed for a trial, the data necessary to achieve that purpose, and the data that are proportionate to that purpose will remain. So this system ensures that less and less personal data are processed, within each building block of the data-driven investigative measure, because data that are necessary for an investigation of a criminal offense might not be necessary for the prosecution of a criminal offense. And here we come to the difference of the purpose limitation principle in the LED context, so the Law Enforcement Directive. The purpose limitation principle, as we all know, is a cornerstone of data protection law. And it was already introduced with Convention 108 in the 1980s in European data protection law, and then taken over in EU law and embedded in, together with the data minimization principle in its own data protection legislation. So today it still exists within the GDPR and the Law Enforcement Directive, but of course in new forms and shapes. And the Law Enforcement Directive actually keeps the old language of Convention 108, that data should be adequate, relevant, and not excessive in relation to the purposes for which they are processed, whereas the GDPR, of course, speaks about the minimum necessary in relation to purposes to be processed. The purpose limitation principle in the LED is so far simpler, and the data minimization principle much more flexible under the Law Enforcement Directive than in its counterpart, so the GDPR. And those differences are very significant and have very important consequences for data protection in the era of big data or AI policing, because there's no need to reduce processing to the necessary minimum under the directive, and controllers under the directive can operate with much less precision. So when we speak about subsequent processing, we also need to take into consideration the question of control and scope. Both the GDPR and the Law Enforcement Directive prohibit the processing, be it further or subsequent, for purposes that are incompatible with the original purposes. But the conceptual difference between further and subsequent processing can be contextualized by the different objectives of the GDPR and the directive. Because the GDPR considers further processing only possible on the same legal basis and by the same controller, whereas the Law Enforcement Directive assumes compatibility of purposes and controllers because of its limited scope in which it applies. Because the LED scope covers only the processing by competent authorities, police, investigative judges, criminal courts, so law enforcement authorities, and only for purposes listed in Article 1.1. So let's call them law enforcement purposes. And in addition, the directive lays down only one legal ground for processing, which is if it's permitted by law. So that means that subsequent processing by the same or another controller is permitted if authorized by law, and if it's necessary and proportionate, as long as it remains within the scope of the directive. So in that sense, the concept of the change of purpose in the LED, of course, taken in the context, could be seen as more protective. So in the context of big data policing and data-driven analysis, if applied correctly, one could say that the law enforcement directive's particular setup of the purpose limitation principle could serve to set boundaries for the use of data in different stages of the criminal procedure and also AI and data-driven analysis. Because the principles of the directive impose limits on the reuse of personal data for law enforcement authorities, other than for which they were originally collected, so on the amount of data that law enforcement authorities can use throughout the criminal procedure. So to use this purpose limitation principle under the directive and its concept in the change of purpose could solve conflicts between those data-driven investigative measures and the right to personal data protection. So what I want to say is that data protection law under the LED and criminal procedural law should speak more to each other and should not ignore each other. So where necessary, criminal procedural law should seek to embed data protection law more throughout the different steps of the criminal procedure. So for AI-driven data analysis, this can be beneficial and fulfill additional safeguards on both sides. So the investigation and prosecution on the one side, and the fair trial aspects on the other. So this is what I meant when I said at the beginning that this is what Moitza also said, that we can use already existing safeguards to embed them more in what we already have. So thanks a lot.
Thank you very much. Thank you very much for the very interesting presentation. I will then give the word to the final speaker, Dr. Lonneke Stevens, who is the legal program leader for the National Program for Data-Driven Cooperation at the Dutch Police. And she will provide us with a law enforcement perspective on these issues.
Thank you, Johan. Yeah, I'm Dutch Police, but I feel a bit like a defendant today. I'm working at a so-called change program at the Dutch Police. And in Dutch, this program is called data-gedreven samenwerken, so together. And it's not easy to translate that to catchy English, but I think it would be something like working together on data-driven policing. And the goal of this change program is essentially to further professionalize data-driven policing within the Dutch police. And lawfulness and ethics are an important part of that, and that's my job. Before I start, I have two disclaimers. First, what I'm sharing here today does not reflect the official position of the Dutch police. It's what my program propagates. And second, I'm not an AI expert, and most of my talk will not be about AI specifically. I will speak about data and analysis of data. And AI is just one of the systems we use within the Dutch police. And in that respect, I'd like to tell you about the program's so-called 6 legal pillars of data-driven investigation. These 6 pillars are themes or legal developments my legal colleagues and I think the police need to work on or must prepare for right now already or in the near future. And why did we write these 6 pillars? I will tell you about them later, but why did we write them? That's because we want to guide the shift towards data-driven policing, because it's still a shift, in a way that's legally and ethically sound. And that doesn't happen by itself. On the one hand, criminal behavior is increasingly taking place online. The online world is international and volatile, and it's inevitable and necessary that new methods of digital investigation are developed. So a guy in a beige raincoat in the shrubbery will not do anymore. So criminal investigation is increasingly becoming investigating data. On the other hand, the amount of data is endless. So collection and combination of large data set can easily be done on a rather naive idea The more data we collect, the more patterns you find, the more criminals you will catch. Can also be done in a smart way, based on good research questions and for legitimate reasons and with good analysis systems. So we need regulation to put into practice smart data-driven policing, smart and legit data-driven policing. But regulation is way behind. It's either technologically old-fashioned, not specific enough. I think Therese already talked about that a bit. It's absent or difficult to translate to practice. However, my colleagues and I said, if we focus on these six pillars, we can already start improving data-driven policing. So what are these 6 pillars? The first one is select before you collect. For the police, relevant information is often part of a larger data set, but also a lot of non-relevant information. So take, for example, it's a very notorious example, the smartphone. The police need the pictures of the drugs that were handed over, but not the birthday pictures of the suspect's daughter. Especially in the early stages of the investigation, it's not easy to filter relevant from irrelevant. Nevertheless, the police do have the obligation to make a data investigation as selected as possible. And this means that we should always ask the question and substantiate it. What information do I need in this case? For what reason and in which data do I expect to find that information? Our second pillar. Is make a distinction between outside and inside storage of data. And what do I mean by that? Filtering relevant from non-relevant data is often only possible after collection. So you need to have 2 regimes in your data governance. One on the data that was filtered out as non-relevant, and one of the relevant data. And for each regime, you need to create guarantees of access and retention. Thirdly, we should not think that once data is in our hands, we can keep reusing and reusing it. So that's about the repurposing you talked about. Current legislation imposes few restrictions on reusing data for other purposes. Once data is in, it can be reused quite easily. And from a police perspective, this is of course handy and also logical. The police cannot function without a strong information position. But because so much data is collected, and data can be analyzed automatically, swiftly, using handy tooling, further processing can take on enormous proportions. And this calls for a rethinking of the conditions under which we consider repurposing of data to be proportionate. Our 4th pillar, oh, I'm being called operation. Our 4th pillar holds that we must develop quality requirements for data analysis methodologies. So for algorithms, and particularly the more complex AI systems, and if these systems are of insufficient quality, the police are not allowed to use them. So we tell our colleagues. So finally, our 5th and 6th pillar, they are formal guarantees. The police need to develop uniform work processes and solid data governance, and the police need to prepare for increasing independent supervision on the collection of data, but expectedly also on the further processing of data. So that about our 6 pillars. I will slowly get to the AI and the contestability topic of today. These 6 pillars, they aim to guarantee a process in which relevant data are collected and processed lawfully and reliably. And that is in a close collaboration between humans and machines. And my point is that contestability of AI-generated evidence within a criminal procedure is in essence contestability of this whole process of big data analysis that was leading up to the evidence in trial. That's easy to say in an abstract and general way. It's not easy to make it happen. I'll pinpoint 2 challenges. One big challenge, well, first of all, let me reflect on the talks here today. They are all still rather abstract. You know, we're talking about this problem in a rather general fashion. And law shaping should happen on a case-by-case basis. You can talk about AI systems generally, but there are so many different AI systems and there are so many different ways in which the police uses them. So we have to, to do it on a case-by-case basis, the shaping of the law and the development of new norms, or old norms in a new jacket. But the challenge then is transparency. For example, if we want to develop standards for AI-generated evidence, we could treat specific data analysis as expert evidence. This would mean that the police should report on hypotheses, scientifically accepted methods of investigation, and that we should explain the evidential likelihood of the results, like with DNA evidence. As a start, we do have a public algorithm register, so it needs to be improved, but first steps are there. Regarding research methods, the police might not want to make criminals wiser than necessary, and hence will prevent transparency in investigation techniques, and hence will shield off analysis systems. And furthermore, this point was already made, not all data analysis produce evidence. They only produce initial information for the investigation, which will not end up in the case file. So you could say, okay, this has to end up in the case file as well and be discussed in the trial, but you could also say that for this analysis, maybe there are reasons the police does not report it, and maybe there's not even time to report all of this. So for this analysis, you will need some other form of supervision other than the trial and the defense and the judge. Already there, almost there, sorry. So that's one challenge I see. Another big challenge is data literacy of all the parties in the criminal justice system. If I read court rulings, I can tell that most judges and lawyers, and actually prosecutors as well, have little understanding of data analysis and the tooling that is used and what is data essentially. At least I don't see the right questions being asked. And if we say that the police must become more transparent on data analysis, it is equally important that what is communicated by the police is properly understood and properly assessed in order to have a meaningful debate. Thank you.
Thank you very much for another interesting presentation. Before I give the floor to the audience for questions, I was wondering whether perhaps some of the panelists have questions for one another based on the talks you have just heard.
Don't want to take away the time for the discussion, but just to break the ice and start with Lonek and...
I expected that you would ask me a question.
And the very end. In our research, especially, we covered the Netherlands in our comparative research, and indeed, one of the arguments which was put forward, and I think it was provoking also to the audience, that law enforcement does not want to reveal all the methods because we don't want potential offenders to actually become wiser and better trained. Now, if we think from the perspective of expert evidence with what you concluded, I am firmly convinced that independent validation of methods and peer studies are important. And what we see today in criminal proceedings, that many AI tools are used without independent validation. So it's one thing to be transparent and explaining your AI and source code and training data, etc. Mm-hmm. That goes very far. And I think it's another level of transparency to allow experts to actually test the algorithm with other hypotheses, other data, and to have an independent validation. Mm-hmm. So I wanted to challenge you on this, and I think your concluding remarks about the problem of transparency, I think it's about what is scientifically acceptable and what is flown expertise, and the literacy question, and I think that's an interesting aspect leading us to the AI Act, and I think the Omnibus, which is now downsizing literacy, but it's about the flown expert, how we know that the expert is actually capable even of telling participants in the criminal proceedings something about the AI algorithm. So that, I think, is a very interesting question, how we implement this literacy throughout the criminal justice process. So validation.
Yeah, so your question, what exactly is your question? So I feel you, do you actually say that we should be transparent on all our AI systems and that they should all be scientifically validated?
I think that all the systems which are used should be subject to independent validation and peer studies.
Well, I think that's impossible. It's a nice ideal. I think more systems should be independently validated. I agree with you on that, but it really depends on how AI on the AI system and the context in which it is used. So I don't agree with you on that. And simply, because it's not necessary, because you should ask yourself, what's the risk here? You see, and we're talking about old problems in a new form. And simply, another point is, there's no time and money to do that. You know, the criminal, it's not science, criminal proceedings are a process in which there's always little time, not enough money, and that's also a legitimate interest. So you have to weigh, okay, so what are the risks at stake, and what are the other interests here? So that's a very pragmatic answer to your question, I think.
Yes,
yeah.
I would challenge you further on that, but I think we should open the floor.
Can I jump in as well? A bit on that, but also a kind of broader problem I think I see. So there's this kind of binary way of looking at AI in criminal investigation. And one way is, I think, what you're presenting, Lonneke, which would be looking at AI as just another tool that we're using, like another method that we're using. And we have, as I was saying as well, we have developed ways of dealing with expert kind of knowledge or different tools. We have, in the European tradition, you have expert witnesses, whatever. In the American tradition, you have the Daubert test, where you actually test the methodology that you're using. And this goes a bit to what you're saying, right? You need to be able to say, this method that I'm using is valid, it has been tested, it has scientific kind of merit to it, which is one problem in itself, and that's already a big problem. The other problem is that maybe we should not be looking at AI as just another tool problem, but rather as a kind of redesign of how we do criminal proceedings. And this is the threat, I think, that's underlying. So because it's not only being used, but it also shapes how other things are being used, it might have a kind of more specific view. And I really like your 6 kind of pillars. I think they are something that could easily be transposed into actual criminal proceeding safeguards. And at the level of safeguards, you don't need them to be super specific. Law in general is abstract, right? What it needs to be is concretized then exactly. by practice, right? So I think one thing is for the police to have kind of a guiding set of principles, but then another, which is, I think, what's more necessary, well, not more, equally as necessary, is to have that embedded in the criminal legislation and the setting.
Yeah, and one of the problems is that lawmakers are, the police feels that, the legislator is not really helping us. So we want those specific rules, because then we can move forward and then we can start a discussion and then we can become more transparent. But if things are remaining fuzzy, it's very difficult for the police to be transparent and to start debate.
Okay. Unless there are perhaps some other questions from one of the panelists, I think I will open the floor to the audience. Are there any questions? Yes.
No, I think you can hear me.
Yeah.
Yeah. Thank you. I have a question here again for.
Yeah. I
But
challenge the audience to have questions for the others.
I'm very curious to hear also.
Yeah.
Of course. My question concerns not much the use of AI tools for investigation, but the development of AI tools. Because while for the use, like we may find more easily a legal basis under data protection law perspective in the national law, often for what I've seen looking into different countries, like for the development, it's harder to find a clear legal basis for that. Do you think, is it so also in the Netherlands?
Yes. We're actually discussing with the legislator right now the legal basis for developing AI analysis, yes. And that's very necessary, but we don't have a clear legal basis yet. Yeah.
Thank you. Any other questions? I see someone.
So, for me, it's also thanks. So, if I may add to that, my question also to the Dutch police. In general, first of all, thanks for your valuable input. And I can say it's good that the police is also conceptually thinking about principles to implement while using those tools. At the same time, especially for the Netherlands, it was uncovered by the Volkskrant and Follow the Money, the cooperation between Palantir and the Dutch police and the secret agencies of the Netherlands. So in general, I understand that there's a platform under own control, for instance, like the platform Nafin.ai in the Netherlands. I understand that you can implement those principles, but if you rely on foreign tools, data aggregator like Palantir, where you have basically zero controls, can you please explain how that aligns with the setting of those principles, and especially the purpose limitation principle?
Yeah, well, that's I cannot say a lot about that, but it's a problem. My personal view is we should not use Palantir.
Is there any kind of development like that? Maybe that's controversial to say, but
I can tell you there's a lot of discussion about this. So it's not that we think, oh yeah, no problem. So we see this problem. I see this problem, and others also see this problem.
My question is maybe what is actively done to address that problem?
Yeah.
Because one thing is to realize the problem, of course, and secondly also Teresa said, there are principles.
It's going to be a long discussion. So my comment is no comment. I cannot comment on that. Sorry. I understand your question that you're curious, but it's not up to me.
Thank you for your question. Are there perhaps any questions for the other panelists? Yes.
Hello, Juraj Seifert from VOB or European Commission. So I have a question for Katalin, but anyone else who wants to reply can also reply. It's actually a follow-up to the previous question, but on a more general level. So is there a need for the European legislator to incite in-house development of AI tools by the police forces, so they don't actually buy products from private companies or especially not from third countries? So is there I don't know, has already something been done, or should it be done in terms of facilitating this in-house development? In the AI Act, should we make clear that for in-house development, the LED applies and not the GDPR, because maybe LED is less strict than the GDPR? So are there any ways, what has been done so far in the legislation, and what can we do more in order to incite this in-house development from a regulatory standpoint? That's my question.
Thank you very much, Juraj, for the question, and maybe others want to react to as well. So if I look at the AI Act and I take it to the concrete, as Lonneke has suggested, not just very abstractly about expert evidence, but you look into in relation to the different tools and how machine learning is integrated into different kinds of already complex forensic or other investigative algorithms. I think that the AI Act is not very helpful because it was not designed with the specific knowledge of how actually investigative tools or forensic algorithms start to upgrade with machine learning and deep learning. So I think that the AI Act is not very helpful, neither for the development nor for the use. I think it has a good philosophy in the sense that one could think that most of those tools that I depicted on the slide would fall in the high category, and we have transparency and explainability. But if you want to then dig deeply, you will see that the AI Act does not catch them at all. So I think that's already problematic, and I think we would need a much more specific regulation for the criminal justice use of AI. And that also then goes to the development of these tools. What are can we actually use these black box AI for these kind of tools in Europe? If you look into Annex 3 of the AI Act, and I don't think that we have clear answers, and we need to have. What we see from practice is that most forensic laboratories use open source AI, so we don't have all this problem of access to the source code, etc., because they start from open source models. But still, the validation and the independent peer review, we have guidelines on that, but we don't have harmonized standards of forensics, for instance. And today, these very soft guidelines actually define the practice on the development of these tools. And I do think that European legislation should go into harmonizing those standards.
I may just add something very briefly to also what Teresa said earlier in her presentation. I think, so the problems that we see in criminal law, in criminal investigation, are very similar to the problems that we see when we use AI in other areas, but also very specific, in the sense that this is a specific area. We all like to think of our own areas as very special and so on. But it is the kind of, it is the area that infringes the most on the rights of the people, right? So it does have a special status. And as much as I think data protection laws are absolutely something that needs to be considered there, and the AI Act is something that needs to be considered, I think, not sure if everyone agrees, but the core kind of place to put guardrails on AI in investigation is criminal law. And there is room for the EU, I think, to do a lot in that respect as well. But that's the kind of core remit that needs to be kind of added to and compounded on by other areas. But I don't see this as something that can be resolved outside criminal law.
Thank you.
Right.
Thank you for the question.
Masha Kalic, Vrije Universiteit in Amsterdam. I have two questions, actually. One is for Mojca and one is for Teresa. Let me start with Mojca. I really like one of your arguments at the end where you basically say we don't need to reinvent the wheel when it comes to AI because criminal procedure has always dealt with new types of, let's say, more or less scientific methods. And I like the comparison with DNA. So I was wondering if you can make some existing safeguards in relation to DNA that ensure the contestability of DNA evidence in criminal trial that we can then also use in AI. Because what's really problematic in AI is making it contestable, precisely because nothing ever ends up at the trial stage. Because as Katalin said, most of it is still used as leads. And I think that will still be the case for a while. And my second question is for Teresa, and that has to do with the specificity of the purposes, right, as required by the LED. I think CJEU case law nicely makes a distinction, one that we have all known for a long time, between the general objectives, right, in Article 1, Paragraph 1, and the actual purposes of data processing that need to be quite a bit more specific. Now, if I talk to law enforcement, then they will say, well, we make a third distinction. What are the goals of our concrete investigation? So I'm wondering, do you see also these three types of, let's call them purposes in a broad sense, as something distinct? Or are the purposes of processing of data the same as the purpose of the criminal investigation taking place? How do these two relate to each other? And what is the level of granularity that you would like to see, you know, in an ideal world? That on the one hand preserves this principle of purpose limitation, and on the other hand allows law enforcement to still have some flexibility in order to find crime and criminals, this level of flexibility that the LED also grants. Thank you.
Should I start? That's not an easy question. So I use the analogy, and I think it's useful, but it can also be, I think, overinflated in a way. So DNA is kind of external expertise, right? We've had that discussion with DNA as well. Can the police do its own kind of testing? And we said, well, possibly, you know, have an independent laboratory doing the testing is a better idea. And this is something that could be applicable to this scenario as well. But then Lonneke will say that's no longer helpful for us, right?
No, that's not true. No, I was actually writing down that, like with DNA, the Dutch Forensic Institute they had a big, they developed methods and a way of communicating, the likelihood of DNA results. And I think the NFI, I think they can do the same with the use of AI.
I think it can be done in a similar way. There's the question of this independent laboratories or the accreditation of who is allowed to use these tools. There's the question of replicability. Can this be replicated in another way? And DNA testing obviously can. AI, depending on how it's used, I think that there are limits to what can be replicated and what cannot. The option to have it open for cross-examination, like that's. But that all hinges on transparency, I think, and transparency in the way it's used, but also, as Katalin said, in the way it's designed as well. So I think opening up that kind of mode of working and using is kind of the prerequisite we need in order to make it kind of closer to what criminal justice standards would need.
May I add something on this? I work with the NFI colleagues actually on forensic probabilistic genotyping, which is already an AI algorithm, not machine learning, but a complex algorithm. And now NFI is upgrading it with machine learning. Now the question is, and DNA I think is a good example because it actually goes into the case file and goes in front of the court and it needs to be scrutinized, or in principle the defense could challenge that evidence. So the question is, okay, you have an expert report and the expert can say something about the likelihood ratio that the FPG analysis produced. But what will be in the expert's report? The expert report will mention the name of the tool, but certainly not mention which kind of AI it's used. So for the defense, it won't be known that there is a machine learning element, for instance, in the new tools used by the NFI. Could the defense ask it? And would the expert answer to that? Yes, in theory, yes. But how come this knowledge to the defense? And this is where I think transparency kicks in. And this is where I believe that it's not enough to work with old rights, but we have to further develop them and think about new ones that the defendant would need to have in the first step knowledge that machine learning has been used in the production of the evidence. And then we can see how it was tested and whether it's an accredited institute and how it's done. These are, I think, then further technical implementations on how to do it, but I think the most challenging point for the defendant, it won't know that there was machine learning used in the piece of evidence which came to the case file.
Yeah, thanks a lot for your question. And I completely agree that there's a big difference between objectives and purposes, because otherwise Article 8 of the Law Enforcement Directive wouldn't make a difference, because it speaks about at least the purposes and the objectives as well as the data. I think it would already be a very good start to have in the specific legislative acts something more than just saying, okay, you can process data for investigating a crime, but you need to be much more specific in terms of what kind of crimes and what kind of data you can use for which crimes. But I think what the message that I was trying to make is that you need to have different kinds of legislation doing the different processes of subsequent processing. And each of these legislative measures need to recognize that you might need different data. And so, you know, the police can say that you need a lot of data, and that might be true. And I didn't say that there needs to be a very strong limitation, but, you know, you need to have this sieving and filtering and identifying, that was everyone was saying, also the police, of the data that is actually needed, and then maybe even a refiltering so that you don't reuse the data that might not be necessary anymore. And for that, you can, on the one hand, look at data protection law and the specific purposes and the specific data, but also at the specific criminal offenses and the gravity of those. So there needs to also come into play a consideration of the proportionality of using data, the categories of data, what kind of data you can use, and then for which specific crimes can those data be used and by whom, and how does this need to change throughout the different stages of a criminal procedure, so that at the end, you know, if we lay it down in those legislative measures, we come to a point where we not only have the proportionate and relevant and good quality data, but we also put in place, during that process, the necessary safeguards.
Thank you for the questions and the answers. Well, I think we have time for one more question. Is there any still left? Yes.
I'm very curious about that independent oversight on every AI system that was suggested. How would that, who would do that in practice, and how would that be concretized? And would you do that in every file, in every case file, or would that be a general validation? How would that work in practice?
Is your question directed specifically, or just for the whole? Anyone who feels
competent to respond
to address this question? Yes.
Yeah. See, that's my point.
I think it's impossible to do it in every case file.
Well, I heard the answer of the Dutch police, and the Belgian police would say the same. But that's what I wanted to point out. It's very easy to say there should be peer review, independent validation. But that's the first question. I know that I'm, as a data protection authority, absolutely in the impossibility to do that, unless I can get 20, 30 people. I get a lot of budgets. I get the expertise, etc., etc. So it's very theoretical.
We have systems where we see this being implemented. So I don't. So when I talk about independent validation. It's independent validation of the scientific method. And one can do this differently. But that can mean if there is a tool developed by the police. And I think one of the big challenges about AI is how defendants get forensic expert assistance. Because the defendant can have access to many things if the law grants them, but they won't be able to actually use any of these defense rights unless they have forensic assistance. And we lack forensic experts, I think, generally in Europe. But if we have more forensic expertise, and I think this is where justice systems would need to invest, you can allow experts, not just experts working in the state laboratory, but other independent experts, because there is also a large private sector, and this can be big business. We see it across the Atlantic. And they can test and think around with the tools, with different data, with different scenarios, in order to validate and see whether they still produce reliable results and replicate results. So this is what I meant by independent peer reviewing. So it's not only one laboratory and a few experts working there, but other experts can actually test the tool as well.
If I may continue, I think you're also kind of building our argument as well, in a way, because obviously you're right. This cannot be tested in each and every specific case again and again and again. It would be useless if we required, human oversight of every single step, in a way, because then what's the point of using it? But it builds towards what we're saying as well, in the sense that if we know that we won't be testing each specific case individually, we absolutely need to know what it is that we're introducing into it. It needs to be tested before we get to use it, right? We need to know what it can do, how it needs to be used to do it, what questions can it answer, and what questions it cannot answer. If we don't know what we're introducing into it, how can we say that what we're doing is actually leading towards, finding what actually happened or not, or proving what it is that we're actually trying to prove? So the question is not of whether can it make our lives easier, in the sense that it makes processes faster, quicker, more efficient, but whether is making things faster, quicker, easier in a way, but also allowing us to investigate things that we weren't able to investigate before. Is it proportionate to the danger that we're introducing into the system? And that question needs to be answered before the police is given the tool.
Would anyone else still like to say something? But I think we have run out of time. I think a lot of questions remain, I think. For now, I would like you to thank the panelists